Hello everyone, welcome to Academy of Civil Services. In today's current affairs session, we discuss the triple talaq. All of you must have heard of triple talaq, and it was a hot discussion in 2019 because the Parliament of India passed the Muslim Women Protection of Rights on Marriage Act 2019. The Muslim women, the main target of this act was banning the practice of triple talaq in India, or making the practice of triple talaq a cognizable criminal offense in India. All of you know that, and if you are going by the procedure of law in India and the penal codes in India, you can see that there are two major things. One is if you are going into the classification of offenses in India, we can make it into two major classes. One is civil offense, another one is the criminal offense. Normally, marriage, divorce, adoption, succession, these things are known as the civil matters. And criminal matters, murder, theft, etc., attacking and attacking a woman, or attacking a decent person, mob lynching, and these matters are known as the criminal offenses. Now, divorce was a civil offense in India, but for a particular community, that is Muslims, the practice of triple talaq has been made a criminal offense by the Muslim Women Protection of Rights on Marriage Act 2019. That is why anyway it was widely discussed. We are not going into the controversy of this act, or we are not going into much into the technical explanation of what is talaq-e-bid'ah or what is the triple talaq. We will do in another video. In this video, we are making an explanation on how this subject may come in our civil services prelims examination 2020, and we can see what are the major provisions of the Muslim Women Protection of Rights on Marriage Act 2019. And it was in news because recently President of India Ramnath Kovind has given his assent for this act. Obviously, all of you know, for passing an act in India, first it has to be passed by simple majority. If it is an ordinary law, this is an ordinary law, then it has to be passed by simple majority. Simple majority means more than half of the members who are present in the house on the day of voting, and they participate voting. If somebody walks out when the voting is done, their vote will not be counted for making the simple majority. Then if something is passed, a bill has to be passed with simple majority, both in upper house and lower house of the parliament, that is Lok Sabha and Rajya Sabha of parliament. After that, when President of India assents the bill becomes an act. It will be implemented in the nation. And anyway, recently President of India Ramnath Kovind has given assent to the Triple Talaq Banning Act. The name of the act is the Muslim Women Protection of Rights on the Marriage Act 2019. And this one, and it has replaced. Earlier there was an act, that is in 1986. After the most famous Shabanu case, Parliament of India passed an act, that is the Muslim Women Protection of Rights on Divorce Act in 1986, and that act has been replaced by the new act of 2019. Now, coming to the major provisions of the act, we can see what are the important provisions of this act. And main thing is that it has declared the talaq-e-bid'ah, the practice of talaq-e-bid'ah. In Islam, talaq or divorce, and divorce, there is a proper way of doing divorce or talaq, that is known as talaq-e-ahsan, and that is a detailed procedure which has been explained in Holy Quran. And actually in Islam, the divorce is supposed to take place after a scientific procedure of negotiations and discussions and the attempt for making compromise between the two spouses, and this is the couples, and this is the actual way of doing talaq. But misusing the Islamic law, a new practice came up later, and that is known as the triple talaq, instantly divorcing the woman. And this has been criticized, and we are not going into the theological part of this, and this is not something encouraged in Islam. Anyway, now The triple talaq, that is instantly divorcing a woman, has been declared null and void in India by this law. Then this is lot of discussions are there whether parliament can interfere in a religious verdict, and parliament can make something which has to be discussed inside the religion, whether parliament has the power to declare that as null and void. We will not go into that at present. We will discuss those things when we are preparing for the mains examination. Now the instant triple talaq has been declared as void and illegal in India. That means if a person, even if a person practices instant triple talaq, that will not be considered as a divorce in India. And second thing is that, and it has made as a criminal offense, a civil offense. Obviously divorce is a civil offense. A civil offense, divorce of any other community in India, divorce of a Hindu couple or divorce of a Christian couple, Sikh couple, Buddhist couple, is considered as a civil offense in India. But only one particular type of divorce, that is among Muslims, and the triple talaq, not all the divorce among the Muslims, and any divorce which is following the way of triple talaq or instant divorce is declared as a criminal offense. That also and will attract an imprisonment up to 3 years and a fine. If somebody practices, the husband will be getting imprisonment up to 3 years and a fine for committing this criminal offense from now in India. Next one is that the triple talaq has been declared as a cognizable offense. There are two types of offenses. One is cognizable, second one is non-cognizable offense. Cognizable offense means that if a woman complains or if a woman puts a petition, that FIR, that my husband has given me triple talaq and divorced me instantly, the police officer has the power, and the police officer has the power to arrest the husband or the person without any warrant. Then there is a chance of misuse, and if there is a difference between husband and wife, and the wife can send the husband to jail, by putting up a false allegation also. Even if the husband did not pronounce triple talaq, wife can file a complaint that my husband has done the triple talaq, then let the police officer arrest him and send him to jail. Then there is a chance of misuse in this clause. That is why it has also been criticized that this offense has been made cognizable offense, that a police officer, and if he gets a complaint from the woman or who has been divorced through triple talaq or from any relative of the woman, the police officer has the power to arrest the husband without any warrant and without providing any arrest warrant. And next one is that something positive here, and that is this has been made a compoundable offense. There are two types of offenses. One is compoundable, second one is non-compoundable. If two persons will be involved in an offense, one is the person who committed the offense, second is the victim. Compoundable offense means that and the victim and the person who committed the offense, they can reach into a conciliation, they can compound the case each other, they can settle down the case out of the court each other, and if the woman wants to withdraw the case, then case can be withdrawn. Then in this case also, if the husband and wife reaches into a conciliation, they have a opportunity to withdraw the case. After withdrawing the case, they can take the decision according to them, whether they want to live together or they want to get separated. Then this is a compoundable case where there is an opportunity is given for reaching into a conciliation between the husband and the wife who has been divorced. Then this is another important thing related to the another related important provision related to the provision of the 2019 Act. Next one is that under this Act, if a woman is divorced, if a Muslim woman is divorced, and she can seek the subsistence allowance and she can seek some either one-time allowance or a monthly allowance from the husband who has divorced her. And this allowance will also, an allowance, it is not a fixed amount, this much amount for each and every woman who has been divorced, and the allowance will be determined by the district magistrate, and who is and in front of whom the case for the allowance comes up. Then the woman has a right to get allowance from the husband if she is divorced, and Muslim woman has the right to get allowance if she is divorced by the husband. Next one is that custody of children. If a woman is divorced, this act mentions that she will have the custody of the woman. Finally, the decision will be taken by the district magistrate, but woman is given the preference to have the custody of her minor children. Major children, obviously, they will decide, and they are free individuals. They can decide whether they want to stay with father or mother, or they want to remain independent, neither with father nor with mother. Here, the minor children, district magistrate is the authority to give the custody, but district magistrate has to give the custody of minor children to the woman, that is to mother, not to father, if a woman is divorced by the husband, if a Muslim woman is divorced by the husband. And these are the important provisions of the 2019 Muslim Women Protection in Respect of Marriage Act. And as we mentioned earlier, the main point of the act is that it has made triple talaq as a null and void practice in India. We will discuss in detail about the triple talaq, about the talaq-e-ahsan, talaq-e-hasan, talaq-e-bid'ah, nikah halala, and these things we have to discuss in detail for the mains examination. There we will discuss, or in another video we will discuss these theological terms in theological terms in detail. In this video, I have brought only the provisions of the new act passed in 2019, which was a major public discussion in India in June-July 2019. Thank you for watching. Stay tuned for another important current affairs video for the UPSC Civil Services Prelims Examination 2020. Thank you once again.